This is Boomer Time, a proactive podcast for baby boomers, about baby boomers, and for people taking care of baby boomers. If that sounds like you, then you're in the right place. I'm Nancy Kogar, an elder law attorney and aging advocate, and this podcast was made just for you. Remember, though, the things we discuss here are not intended to be legal advice, and no attorney-client relationship is established by this podcast. Hello, my friends. This is your host, Nancy Kogar, and this is Boomer Time. I am so glad that you've joined me. As you know, this podcast is dedicated to talking about all issues related to aging. It's about baby boomers, and for people taking care of boomers. I am an estate planner and elder law attorney here in Tennessee, and I have seen too many people unprepared for the issues that come with aging. That is why I created this podcast, to get those resources in your hands now so you're prepared for later. I also wanted to build community because this is tough stuff. And you are not going to do it alone. We are in this together. So this is episode 7. Today we are talking about wills, last will and testaments, and more specifically, do-it-yourself wills. Lots of people try to save a buck doing it themselves. That is true, but I'm here to tell you that if you're doing that, that will often come and lead to disaster. Today, we're going to talk about 10 reasons that's the case. So believe it or not, half of all folks out there have no estate planning documents at all. And that's really scary to someone like me as an estate planning and elder law attorney, because in practical terms, that means if something happens to you and you die unexpectedly and you have no will, you are leaving the decisions about what happens to your assets up to the state in which you live. So if you live here in Tennessee, we call that intestate. It can lead to all sorts of trouble. Compound that with circumstances today, like if you have a blended family or a second marriage, and it can get only worse. Quite frankly, you're in store for a big mess, and I've come in contact with them. Not only that, if you don't have powers of attorney and you're incapacitated, say in an unexpected car accident or another injury, your loved ones may be faced with filing a court action or an expensive conservatorship in order to gain the authority to make decisions for you. Healthcare decisions, the ability to pay your bills, to help with your care, all kinds of things. All because you didn't have estate planning documents. Now, add that on top of the do-it-yourself factor. I will tell you that I do not advise you to go on the internet and look for some cookie-cutter one-size-fits-all form. That's also a potential minefield. You know why? Because Tennessee is known as a statutory formality state. What does that mean? That means if it doesn't comply with what the state requires, then it's not valid, period. So imagine having your own do-it-yourself documents and an emergency strikes, and at that time, your family goes for your do-it-yourself docs, and guess what? They're not worth the paper they're written on. Ouch. We don't want that, do we? Well, I for one want to prevent that from happening in your life. That's the reason we're talking about avoiding those do-it-yourself disasters today. There is a lot to think about, believe me. Stay with me because I think you're going to have some really valuable lessons and takeaways from today's podcast. And I'll start with those. Stick with me. We'll be right back after this. Welcome back. This is Boomer Time, and I'm your host, Nancy Kogar, an elder law attorney and estate planning attorney here in Tennessee. We are talking 10 reasons do-it-yourself wills don't work. In fact, do-it-yourself estate planning should be avoided altogether, in my opinion. I've seen some really awful stuff in my time, trust me. And a lot of times it leads to litigation, and you don't want that. I want to prevent you from making those same mistakes. So that's what we're going to talk about today. So here we go. Let's consider some important food for thought that may save both you and your family money, time, frustration, and even conflict and time in court. So number one, I've already mentioned this, but it is worth hearing again. Generic, one-size-fits-all, fill-in-the-blank forms or internet-based templates likely will not address your needs and probably will not be enforceable. Okay, these kinds of mistakes are usually not discovered until it's too late. I'm talking about after you pass away, because when people make a will, it's often tucked away in a drawer and never seen again until the will maker passes away. Guess what? Don't do that either. Because it's worth having a periodic review of your will and other documents. Further, if you have unenforceable documents and or you wait too long or too late to change or update those documents, i.e. if you're no longer competent to make your estate planning documents, then that is going to lead to a costly and often traumatic court-supervised matter like a conservatorship, and that may linger on for months or even years. We're going to have a separate podcast that talks about conservatorships, and that is tough, tough stuff. You want to avoid that if you can. Number two, generic documents. Same issue, but different problem. They simply miss the mark, in my opinion. You know why? Because they just don't address personal and family needs. They're just not appropriate for specific assets that you have or circumstances. Number three, making bad or inappropriate choices for executors and or other fiduciaries, including your powers of attorneys or if you have a trust, a trustee, etc. You'd be surprised about this one. First of all, states are specific about who can and cannot serve in those positions. Did you know that? These positions are considered fiduciary positions. So some appointees may be unable to serve or even unqualified to serve because they have bad credit or even have a criminal background, convictions. If they have a felony conviction, they can't serve as a fiduciary. Even so, they may live out of state. And Tennessee has a statute on the books that is limiting when there's someone that lives out of state that wants to serve as a fiduciary. Number four, failure to properly inventory and as a result, administer your assets. This is really a surprise. You would think people would keep track of their assets, but believe it or not, assets get lost all the time. Matter of fact, there are over 50 billion with a B in unclaimed property in Tennessee and other states because of property of loved ones who died and their heirs had no knowledge of those assets. Can you believe it? Inventory of assets as part of a detailed and comprehensive estate plan is critical. And that estate plan needs to be updated over time, people, because we accumulate things over time. I will say, especially when it comes to older adults, they grew up in an era or were adults during a time when it was advisable to have money in many different banks. So as a result, they have bank accounts in many different banks. I see this all the time, and it makes it confusing unless you have a very detailed inventory of where these bank accounts are located. So I would really pay attention to that. We've had administration of estates, and we've found some surprises sometimes. We've had to reopen estates from time to time. So this is important. Number 5, failure to address critical planning issues. What does that mean? It means guardianship issues for minor children. You need to address the issue of an emergency or temporary guardianship issue in an emergency that may come up, or even longer term guardianship. What happens if you're traveling and you're killed? And what happens to your minor children? Who do you want to raise them if you die and your children are minors? You don't want them to get into the system, and you need to have something in place so that who has your values, who shares your ideas about raising children, is the one that is given that edict or the power in your documents to take that on. And you've talked to them about that. That's no small charge to raise a child. So you need to have these things in place. Because if you don't, as I mentioned a few minutes ago, they will go into the state system, at least temporarily. And that is not good. That can be very traumatic, in addition to, losing your parents. So let's look at these things. In addition to critical planning needs, as far as guardianship, there's also special needs issues involving family members that need to be addressed in estate planning, i.e. family members with disabilities. These things need to be handled with special cares. And inheritance, if you don't handle that properly, that can cause a family member to lose their eligibility or benefits if you don't take the right care in preparing for how they might receive an inheritance. That can be devastating. You can't do that with a do-it-yourself will. Just simply bad or insufficient planning can lead, and I've seen this too, can lead to family conflicts like you've never seen before. It's awful. And that's because we're talking about money and other valuables. Relationships are just been destroyed over less. And I have been seeing more and more litigation in probate court, including just protracted, expensive litigation between family members. That it's just long-lasting, no chance of settlement, permanent damage to the family unit. Just awful. So we're going to be taking a break. And when we come back, I'm going to share the remaining points of our 10 points of why do-it-yourself wills, I think, will lead to disaster. And also help you save some time, money, and time in court if you do what I tell you to do. I think, in my opinion, of course. But stay tuned, and we will be right back. Welcome back. This is Boomer Time, and I'm Nancy Kogar, your host. I'm an elder law attorney and an estate planning attorney here in Tennessee. And today we are talking about the 10 reasons I say do-it-yourself wills don't work and in fact lead to disaster. So I'm trying to help you not go there. This is about helping you in all kinds of preparation for aging, of course. I want to help you through that process. And we are talking about do-it-yourself wills. Don't do them. So we're up to number 7 in our list of 10 reasons. Number 7, I'm looking at those state requirements again. State laws. Every state has different laws. Interestingly enough, if you have, say you moved from Arizona to Tennessee, your Arizona will is valid in Tennessee as long as it's valid in Arizona. You probably didn't know that, but it's because of our lovely Constitution, which is still valid in the United States. That's a good thing. And it's valid in Tennessee if it's valid in Arizona due to the full faith and credit clause of the Constitution. So as long as we have that, you can find that your will in another state will be valid. However, we will have to apply Arizona law. Interesting, huh? And Arizona has its own state formalities. I don't know what those are because I don't practice there. So that's another issue. You'll have a Tennessee lawyer here if you're in Tennessee. I digress. This is what you get when you have a lawyer that thinks about all these different scenarios. But Tennessee has its own state formality requirements, which I did mention before. And because of that, do-it-yourself generic documents may not be enforceable or valid. For instance, did you know that handwritten wills are valid in Tennessee, but they have to be written entirely in your handwriting? And there are some requirements in order to make sure that they're found valid by the court. So it's not as easy as just writing it in your handwriting. And, why take that chance? Number 8, this is kind of a simple thing, but, you might not think of it. Did you know that not all lawyers are the same? You want to make sure you hire an attorney who specializes in estate planning. And if you're aging and maybe you have some special needs, you really should look to someone with some knowledge of long-term care and aging, like an elder law attorney. The law is vast. No one lawyer can achieve or maintain expertise in every area of the law. I can't do that. For that reason, make sure that you hire a lawyer whose practice is specifically dedicated to estate planning and elder law. It matters. I always say, if you needed brain surgery, you wouldn't go to a podiatrist, would you? I know I wouldn't. So make sure the person communicates well with you too. We don't all communicate the same. I like to make sure there's a good fit. So I think that's important too. Number 9, we're getting down there. Cost. That's a biggie, isn't it? What should you expect to pay for estate planning? I get asked that a lot. Here's my answer. It'll sound like a lawyer's answer. It depends. There are a couple of factors, really. Most of all, it depends on the needs of you and your family, honestly. So, first step would be making an appointment with a lawyer to talk through these issues and ask questions. You need to get some options, different scenarios based on your needs, okay? Then decide what works best for you and your family. I wouldn't shortcut it just based on, price. This is important. You've worked to accumulate things your whole life. Don't shortcut it. You need to protect your family and how the things you've worked so hard to attain in your life get treated after you die. Also, how you're treated when you're incapacitated. That is crucial. And you want to have someone who's a professional who is going to be able to guide you over the long term, not just give you a form and say, thanks a lot, and have you walk out the door and never see you again. You want someone that's going to work with you, to alert you when the law changes, to respond to you when your needs change, because your estate plan should reflect those changes. And number 10, estate planning is complex. You probably noticed that by my list. You are not a lawyer, or maybe you are if you're listening here, but most of us, I'm a lawyer, of course, but most of you listening are probably not lawyers. Do-it-yourself wills could cost you a lot of money in the future, whether you realize it or not, when it comes to taxes, Medicaid recovery, creditor claims, There are all kinds of things lurking out there. So it could also cost your loved ones time, pain, emotional strain, court expense, all kinds of things. So don't try to save a buck or two. You're going to end up costing yourself a lot more down the road. Trust me. So a lot to think about, huh? And a lot could go wrong. And like I just said, you spend a lot of time working hard, saving, accumulating, investing, and building your nest egg. And whatever you want to pass on and leave to your loved ones, why in the world would you want to cut corners when it comes to protecting sure it gets passed on with as little problems and cost as possible? This is important stuff, really. And really, your life could depend on it. So we've covered a lot of ground. I'm going to take a break. But when we come back, I'm going to share a little bonus thought, and then we're going to share some final thoughts and some encouragement. So stick with me. I'll be right back. Hello, hello. Welcome back. This is Boomer Time, and I am Nancy Kogar, as you know. I want you to stay tuned. I'm going to have some resources available for you at the end of the show. If you've been listening, that I love resources. And I'll have some more information about how you can stay in touch, too. You go to my website, nancykogar.com, and you can subscribe to our newsletter there, which is called Elder Law News You Can Use. That's our monthly newsletter, and it has great articles in it. I always learn something when I read it. So I definitely recommend that you check that out and subscribe to it. There are also, other episodes of Boomer Time there, and you can subscribe to follow Boomer Time. You can also go to Apple Podcast, find the podcast there, or Spotify. And it is on our website also. And you can find us on Facebook, like our faith page. And we got all kinds of stuff posted there too. I'd love to connect with you there. So I hope you found this episode helpful. I think it's been enlightening. I always enjoy talking about some of the things that could go wrong when you don't pay attention to how complex something is. You don't know what you don't know. I've got some final thoughts here, but I also wanted to share some bonus kind of things that you may not think about when it comes to estate planning. I always tell my clients, I want to hear from you, because when I make estate planning documents, I want those estate planning documents to change with you as your life carries on. You're not going to make a document and stick it in the drawer and just say that's good. No, because you have life events. Things change in your life, and I want to hear from you when those things happen. What are those big life events? If you get married, and unfortunately, if you get divorced, I need to hear from you. You have a birth of a new child or grandchild. That changes how your estate may be distributed. I hear from people when they've had a child pass away. It's difficult. Or a spouse. That's something that calls for changes in an estate plan. Unfortunately, a lot of times when I meet with people, they've been diagnosed with some catastrophic illness, or they've got a long-term disability they're now dealing with. We've all seen how busy it's gotten around Chattanooga. I am talking to a lot of people that have relocated here from different states, and they are making Tennessee wills, and I think that's a smart move. There are people that come to me that have made significant changes in their assets, or just need to restructure things. And I work with financial advisors all the time. I think that's an important part of estate planning as well. That's often overlooked. And even if you buy or sell a business, hey, that's a big piece of your life. So those are bonus thoughts, Think about that. I also wanted to share a couple stories about estate planning. I started to think about some of the people that I've worked with, and I thought this might be helpful to you to kind of think about your own circumstance, but just a couple short thoughts. So I hear from people from time to time that they say, oh, I don't think I really need a will. I don't really have anything, and it'll just go to my kids. That's what they'll say to me. Well, all right. But how do you know that? I see so many contests now. And if you don't have a will that's written to address some of those things, you're just setting yourself up for a contest, in my opinion. Also, if you don't have a will altogether, then you're just relying on the state statute to handle how your estate is, administered. You may have the public administrator assigned to administer your estate. In any event, you need a will. You do not want to just aimlessly, haphazardly leave it up to the state of Tennessee's statute to decide who gets what from your estate. The other part of that is, if you get put into court, your estate gets put into court, you have opened yourself up to creditors. Okay? You need to think about that. I hear from a lot of people that are concerned about getting into a nursing home, exposing themselves to TennCare. If you do nothing and you don't plan, then you are just planning to fail. If you have a house, there's some things you can do to plan for your house to be protected in your estate, but you have to plan. So I had two different kind of circumstances. I had a younger couple come to me. They have 2 little babies, and they're probably in their early 30s. I met them at a family reunion. Not my family, but I was invited to a family reunion to talk about estate planning because the person running the family reunion was kind of irritated that no one was taking planning for your life seriously. So he invited me to talk about that. I thought that was kind of funny, but he's like that. He's a good friend of mine. So I shared, and they were all kind of wide-eyed about all these things that could happen if you didn't have estate planning. So one of them came to me, and that was the one that was the youngest, okay? And came with his wife. And the reason they came was because they were concerned if something happened to them, that their 2 little children might end up in the system. And they wanted to make sure that their parents and vice versa would have temporary guardianship and then full guardianship so that they wouldn't get stuck in any kind of system, even in the interim. I think that's smart. I mean, to me, that I succeeded in protecting that family. So I think that's lesson learned. That's they got it, right? Okay, here's another story. So woman comes to me. Her husband passed away. They never had any children together. She's older. All her brothers and sisters have passed away. Her mom and dad have passed away. She really has no one left in her life. She doesn't even have anybody to really serve as executor. But she's got a lot of money. She doesn't really know what to do with it. Why bother? Why bother? Well, we talked for a while. What a wonderful opportunity to leave a legacy to your faith community, to charities. And that's exactly what she did. After we talked, she thought about who she'd like to leave something to. And she made a wonderful plan to leave to several nonprofits and to her faith community. What a wonderful legacy. She got it. She got it. Because had she not had any heirs remaining, do you know where that money would go? The state of Tennessee. You don't want that to happen either. So anyway, that's enough preaching for me for the day, I think, huh? But no, seriously, I really hope that this has been helpful to you. Send me, if you have a question or you have a comment, I always like constructive comments, send me an email. I enjoy your questions. I enjoy your thoughts. If you have a question, something I didn't address here, I may talk about it on a future show. So I'd love to hear from you. And with that, as I have said before, I am a person of faith. I believe in the power of prayer, and I know this is tough stuff. And as I've said, also, I want to build community because I know caregiving and aging is not easy stuff. So I want you to know in part of this podcast that you are not alone out there, and I am advocating for you. And I want you to know that you are part of a community here. So in that, I just want to take a moment to pray for you and pray for you in what you are doing and what you are facing right now. So just bow your heads with me and we'll just have a moment of quiet and prayer. So, Heavenly Father, just thank you for the opportunity to speak to these individuals today, to share some of the pitfalls that may come from not knowing any better and relying on someone with skill and expertise in making estate planning documents. Help them to retain this information and protect them from making mistakes that may be costly and painful. And help them in their daily lives in caring for their parents or other older adults, and open doors for them in that work so that they can find what they need and find the answers they're looking for. And give them strength where they're feeling weak and rest where they're feeling tired. And help us to continue to offer the help and advice and encouragement that they need so that we can continue to provide what we need to provide and want to provide here on this show, the Boomer Time Show. Because I want to be a resource for you out there that you come to and a respite. So this is where you get some strength and encouragement, right? Yes. So we pray that all in Jesus' name. Amen. All righty. What else we got, Nay? Nay, my super social person extraordinaire is here with me. I can't get this show done without her. So I just want to acknowledge her today. And I have had fun today. This has been a busy week, but I have had fun today. And I hope you enjoyed this podcast. And we're going to do it all again next week. And if you have an idea for a show, I did have a lady reach out to me who said she would really like a show on dealing with parents that are not very cooperative. So yes, that's an important issue, and we will address that one. I have some thoughts about that and some advice. So thank you for sharing that. And yeah, we can talk about that. So, all right. Well, have a great week, people. And I care about you. And we are in this together. Okay? Until next time, I'll see you. Thanks.